a Supreme Court ruling that changes the game. While news cycles chased celebrity scandals and political squabbles, something historic slipped under the radar. The U.S. Supreme Court handed down a 9-0 unanimous decision that may be the most significant blow to state-level assault weapon bans in years. The ruling didn't even use the words gun control, yet its implications are seismic. From coast to coast, restrictive laws targeting AR-style rifles are now on legal life support. If you own a rifle like the AR-15, or you believe in constitutional gun rights, this is your moment. What seems like a case about exports and lawsuits is quietly rewriting the legal standard for what's protected. Welcome to Survival Lawline, where we break down the truth the media won't touch, and your constitutional rights come first. Stay close. I'll break down every twist, every legal bombshell, and what comes next. Please subscribe to Survival Lawline so you never miss any update. Let's get into it. Chapter 1. The Mexico lawsuit that started it all. In 2021, Mexico filed a bold lawsuit against top U.S. gun makers, names like Smith & Wesson, Glock, Colt, Ruger. They claimed these companies knowingly funneled weapons to drug cartels and should pay damages. The demand? Over $10 billion in liability, and sweeping controls over how firearms are distributed. It was a legal Hail Mary, trying to use U.S. courts to impose foreign gun control. Mexico alleged that the distribution system facilitated straw purchases and illegal sales across the border. They argued the manufacturers marketed military-style rifles to appeal to cartel demand. The case passed through lower courts with fierce debate over liability and immunity. The First Circuit revived part of the lawsuit under an exception to immunity laws. That judicial back and forth set the stage for the Supreme Court's intervention. Because at the heart of this case lies a question of whether American firearms makers can be held liable for the misuse of their products, especially when sold and trafficked illegally outside U.S. borders. Chapter 2. The 9-0 rejection. Gun makers protected. On June 5, 2025, the Supreme Court issued a unanimous decision. All 9 justices rejected Mexico's attempt to sue U.S. gun makers. The court held the case was barred under the Protection of Lawful Commerce in Arms Act. Justice Elena Kagan's opinion made clear the lawsuit didn't meet the legal threshold for liability. The case was dismissed under PLCAA's immunity protections. Mexico failed to plausibly allege that gun makers aided and abetted criminal actors. The complaint offered broad allegations but lacked specific facts of intent or coordination. The court ruled that indifference is not enough to pierce the immunity shield. This decision is a massive victory for the firearms industry. But what makes it transformative is a single sentence buried deep in the opinion, a sentence that may dismantle assault weapon bans. Chapter 3. That sentence, everyone's quoting. The ruling centered on Mexico's liability, but hidden in the legal text was something extraordinary. Justice Kagan wrote that AR-style rifles are widely legal and commonly owned by ordinary citizens for lawful purposes. That's not commentary, that's binding dicta in a unanimous ruling. It's now a constitutional fact from the highest court. AR-15s aren't fringe, they're mainstream. The court declared that usage by millions makes the AR legally protected. It affirmed the common use standard central to Heller and Bruen. That language was adopted by all 9 justices, giving it weight. Legal teams are already citing it in state-level assault weapon cases. When the Supreme Court labels a weapon common and lawful, it undercuts every ban built on argued danger. That line transforms countless bans into presumptive violations of the Second Amendment. Chapter 4. How Heller and Bruen fit into this. To see why this matters, you need to understand the foundation. Heller, 2008, declared Americans have the right to keep arms commonly used for lawful purposes. Bruen, 2022, refined that courts must test gun laws by historical tradition. This new ruling links them. If AR-style rifles are deemed common and lawful, bans lose justification. Heller's common use test becomes central again. Bruen requires that restrictions align with historical precedent. The new ruling provides modern grounding to extend protections. States arguing bans must now deal with the court's factual finding on the AR. That changes the legal battleground. No longer can courts claim AR rifles are too dangerous or exotic. The Supreme Court says otherwise. State bans now must stand against that presumption. Chapter 5. The legal dominoes are already falling. Already the landscape is shifting. Lawyers challenging bans in California and elsewhere are citing the 9-0 ruling directly. Federal judges, once hesitant, are rethinking how they balance features-based bans. The Supreme Court's words are being used as a battering ram against old restrictions. In Miller v. Bonta, California's assault weapon ban is under renewed scrutiny. Attorneys argue states can't ban something the Supreme Court called lawful. Judges are encountering defenses built on the new dicta. Legal strategies are redirecting toward dismantling features-based prohibitions. This isn't speculation. Lawsuits are accelerating. The momentum favors gun rights once deemed fringe. Now the fight is shifting from defense to offense. Chapter 6. States with bans in the crosshairs. This decision doesn't just affect California. 10 states plus DC have bans targeting rifles based on appearance or features. Many of those laws hinge on terms like pistol grip, collapsible stock, or flash suppressor. But if AR-style rifles are protected by common use, those bans are facing existential threat. Illinois, New York, Maryland, and others have AR bans or strict limitations. Many bans were upheld under arguments of danger, not tradition. Plaintiffs are filing new lawsuits citing this ruling. Courts must now reconcile state bans with Supreme Court's factual findings. If one by one these bans fall, we move toward nationwide consistency. This ruling may be the first legal hammer to crack the foundation of state-level bans. Chapter 7. The opposition scrambles. The reaction from anti-gun politicians, judges, and activist groups has been fierce. During recent hearings, some judges misquoted or mischaracterized the AR. Others suggested constitutional rights may vary by state. These responses expose desperation more than reason. Some judicial panels mispronounced AR-15 as machine gun. Others floated the idea that rights in one state could differ from another. Politicians accelerated push for new legislation in response. Advocacy groups filed emergency appeals and public messaging campaigns. When your narrative falls apart, the spin begins. But spin has limits against direct Supreme Court language. They're scrambling because they know their arguments are unraveling. Chapter 8. Why this ruling is more than symbolic. This isn't a narrow gun company shield ruling. It alters the factual core for every feature-based restriction. By elevating the AR status to common use, the Supreme Court is shifting burden onto states to justify bans. They can no longer rely on speculative harm or appearance-based fear. States must show historical analogs justifying bans on AR features. The presumption now favors possession unless historically prohibited. The ruling strengthens Second Amendment claims beyond just assault weapons. It may trigger new challenges to restrictions that use feature-based logic. This shift marks a broader realignment in how courts view gun law. It's not just a victory for manufacturers, it's a constitutional inflection point. Chapter 9. The Battle for National Uniformity. Before this, rights varied wildly by state. What's legal in Texas might be criminal in New York. The Supreme Court's 9-0 dictum challenges that patchwork. It demands a more consistent national standard. The decision forces lower courts to align with the Supreme Court's factual findings. It reduces chances for split-circuit reasoning. States with restrictive bans face mounting pressure to revise. Legal momentum favors national coherence in Second Amendment law. We're seeing the beginning of a unified legal doctrine. Not local experiments, not piecemeal rulings. This is constitutional clarity. Chapter 10. What's next? The legal wildfire begins. The ruling is out, but the fight has just begun. States will file new lawsuits, amend or repeal bans, and test the boundaries of the opinion. Courts will be forced to take sides. Will they honor the Supreme Court's language or defy it? What follows will determine whether this ruling is an anomaly or the foundation of a new era. New challenges in all states with assault weapon bans are expected. Legal briefs will cite the Supreme Court's AR-15 language as binding precedent. Legislatures may repeal bans rather than face defeat in court. The Supreme Court may take up a feature ban case soon to clarify scope. We're in the opening act of a legal revolution. The next 12 months will define the battlefield. If the momentum holds, the Second Amendment may win its greatest chapter yet. This is more than a win, it's a turning point. The Supreme Court's 9-0 ruling did more than kill one lawsuit. It planted a constitutional stake deep into feature-based bans across America. For years, AR-style rifles were fought over in labs and legislatures. Now, they stand under the full weight of supreme authority as lawful, common tools. At Survival Lawline, we dissect, analyze, and fight for your rights. So subscribe now, share this video, and stay locked in. The legal timeline is accelerating. Don't miss a minute of the next wave.